Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorian Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. Moorish Empire, traveler on the land, bitch snitch, Moorish Empire, God dang, you're right, traveler on the land, bitch snitch, the late evening West people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good night, good evening, everybody. Whoever you are, wherever you are, whatever you're doing, and all that other fun stuff. I'm just glad you're doing it here with me. Legal Vices on this little old channel that we like to call Legal Vices. Sarah Boon, that's what we're doing today. We are doing some Sarah Booning. It's motions hearing day today. So that'll be fun. So what are we going to do with the motions hearing? They're still in the middle of jury selection. My understanding is they have brought in 2 groups of 50, maybe only 1 group of 50. I'm not sure, but they've narrowed it down to a few potential jurors. They're doing motion hearings today. Then they're going to bring in another batch of potential witnesses and see if they can narrow it down further. The goal is apparently to start opening statements either Thursday afternoon or Friday morning. So we're just going to have to play it by ear. Tomorrow we'll be doing day 1 afternoon and day 2 morning of the Leilani Simon trial that we did yesterday. We'll go back and we'll revisit that tomorrow, unless there's more Boone stuff to talk about. And there may be some more Boone stuff to talk about because, hey, there is another last minute motion that just snuck in under the radar. So we got to look at that. Now, the court is supposed to convene in about 20 minutes. So we don't have a lot of time to get through what we need to get through, which is one, state's objection and motion in limine to exclude the decedent's medical records. They want Sarah Boon's medical records thrown out for a good reason, I think. So we got to do that. And then with whatever time we have left, we will look at another one of her letters that we haven't got around to reading yet. Right. Quick housekeeping stuff. As always, the emotional support potato pig dog cam is on deck. We are locked and loaded and ready to emotional support potato pigify if we get to that point in the show. And let's see, where are we? Ladies and gentlemen, we are at day 35 of the emotional support potato pig dog cam. It is locked and loaded, and there are emotional support potato pig dogs standing by to help you. We just got to get to unlocking that particular achievement. So if it happens, it'll be day 36. Let's see if we can get to day 36. It's entirely up to you. And as we are going to be doing this live, the normal trial rules will apply. If any super chats come in, gifted memberships, whatever, or if there's anything in the chat that particularly catches my fancy that I want to talk about, we'll wait until there is a natural break in the trial, whether that in the hearing, whether that be the judge calling them up, whether it be asking for some additional time, whether it be taking a break, whatever it is, that's when we'll address these super chats, because I don't want to talk over the judge or the lawyers unless it's absolutely necessary to do so. But I will flash them up on screen so you know they were seen, and then I'll read them out and address my response to it, whatever it is. And again, super chats are not required, not obligated, not even begged or grifted for. I'm saying anything that comes in is graciously and gratefully accepted. And if you're gonna part with your hard-earned money to support the channel in any way, the least I can do is guarantee you that I will read and address whatever it is your super chat or you have to say. That's my promise to you. All right, with that, we have our daily like and subscribe poll. We've currently got 431 people here. And again, the hearing is supposed to start in 20 minutes. So I'm monitoring Court TV. Sometimes it doesn't always refresh well. So if anybody notices it beforehand, let me know. It says they're going to start in 17 minutes and 51 seconds. So until then, let's look at some stuff. The first thing is the like and subscribe poll. As I mentioned, we currently have 444 people here and 182 likes. Come on, people. That's like 340 of you haven't done your job. Okay, 240 of you haven't done lawyer math. 240 of you haven't done your job. Get down there and hit that like button. You like this. You like the trial. You like this channel because you're here watching this trial. So, just get out of the way right now. And if you haven't subscribed, I would please, I would beg you. That is one thing I will beg for. I don't beg for the super chats, but I do beg for these subscriptions because I like you and I know that you will like me in return. We're pushing our way towards 100,000. We reached 81,000 2 days ago, and now we are currently at 80. Or was it yesterday? I think it was yesterday. It was yesterday, wasn't it? I don't know. I think so. Yeah. All these days just kind of blur together on my schedule. But currently we have 81,040 subscribers. So we're pushing up against 81,100. So hit the like button, hit the subscribe button, come over here and take our like and subscribe poll. Today's like and subscribe poll is, what is Sarah's greatest strength? What is the greatest strength that may help to rescue Sarah at the end of the day? What inner strength or what quality does she have that could lead her to a not guilty verdict? Your answers are her warm and charming personality. She works well with others. She excels at everything she does. And finally, her ability to create new words. we noticed that in particular during the reading of additional letters the other day. She didn't have the right word, so she just made one up quite a few times. And just right before we dive into this new motion in limine, I want to give a very, very humble and gracious acknowledgement to Matilda. Hello from the Netherlands. Thank you so much, Matilda, all the way from the Netherlands, kicking us off at the first super chat of the evening with €2. Hello from Korea. And Canonical Heat, dropping the heat with 10, there you go, Legal Vices memberships. If you are one of those people that's got one of the 10 Legal Vices gifted memberships, you make sure you give Canonical Heat a super special shout out and a thanks, because that is incredibly generous. It's so generous, in fact, it's already put us halfway to unlocking day 36 of the emotional support potato pigs. Let me put up a quick banner here that says we're waiting for the hearing to begin. Let's see. Banner, create banner. We are waiting for court to begin. Please stand by. And add banner. And boom, there we go. We are waiting for court to begin, so please stand by. That is really, really big. That is like obnoxiously big. So let's scroll. If you scroll it, then it makes it smaller for some reason. There we go. Scroll it. We're waiting for court to begin, so please stand by. And while we're waiting for court to begin, we have a new motion filed by the prosecution. A new motion followed by the prosecution. It is a state's objection and motion in limine to exclude the decedent's medical records. Sarah, her lawyer, wants George Torres Jr.'s medical records brought into court. Well, let's see what problems the prosecution has with that. So let's bring up the oldie screen here. Boom, there we go. Let's get it on. State's objection and motion in limine to exclude decedent's medical records. And this was filed on October 14th at 9:51 p.m. We have our magic court words here that we have to say. We're required to invoke the magic words of law. Comes now the state of Florida by and through the undersigned assistant state attorney and states and alleges as follows. Ding, 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 incense, incense, holy water, holy water. The magic words have been said. So tonight, this is October 14th, like yesterday. Well, I guess about 36 hours ago. Tonight, the state received 550 pages of medical records regarding medical treatment that the decedent received in 2017 and 2018. 550 pages of medical records for 2 years of medical treatment of George Torres in 2017, 2018. And again, this incident didn't happen until 2020. The defendant acquired these records in January 2022. The state adopts all arguments and authority cited in state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until defendant testifies to a justifiable use of deadly force. So in other words, for the same reason, the same legal basis that they're trying to exclude the battered spouse syndrome evidence, they are using to exclude George Torres Jr.'s medical records from 2017 and 2018. The defendant, even in her most recent iteration of what happened, coming out with a boom right out of the gate. A little, she keeps changing her statements. The defendant, even in her most recent iteration of what happened on February 23rd, 2020, it seems that she changes her stories a bit, does it? Has not set forth the legal grounds to claim self-defense. Okay, so even her most recent version of the story does not include any legal grounds for claiming self-defense. Now, assuming in italics, which means he doesn't think that they will, assuming, as we say in the legal world, arguendo, assuming arguendo or in argument that she does so at trial with a different version of events than prior incidents of violence committed by the decedent that she was aware of would be admissible to show the reasonableness of her fear of imminent great bodily harm or death. Okay, so if she does through a different version of stories that she tells at trial, give evidence that it was reasonable and there were legal grounds for her to be claiming self-defense, even if she does that, then the prior domestic situation committed by the decedent, by George Torres Jr., may be admissible to show that there was a reasonableness of imminent fear or death, imminent fear of bodily harm or death. But these records are irrelevant. So how many did they drop? They dropped 550 pages, and the lawyers for the prosecutors, they are arguing that those records, almost all of them, are completely irrelevant. These records are irrelevant. 487 pages regard an incident
I tried to make that a little bigger. It didn't work. The records are irrelevant. 487 pages regard an incident on December 24th, Christmas Eve, 2017, where the decedent, where George Torres Jr. was beaten so badly he needed facial reconstruction surgery. This is not relevant to whether the decedent committed a prior act of violence that the defendant was aware of occurring. If the incident that resulted in these injuries is somehow made relevant, the severity of the decedent's injuries is not relevant. If the severity of these injuries is somehow relevant, then the defendant should narrow it down to the pertinent narrative history of what the decedent said happened and the treatment provided. This could be done in a handful of pages. So we don't know what happened. We don't know who beat him so badly he needed facial reconstructive surgery. But they're saying all of this is irrelevant. Just what did he say about it? What was his version of the story? That's all we really need to know. The 2018 incident is also not relevant. The history provided by the decedent was that he put his hand through a glass window the day before, and his wife made him go to the doctor the next day. He received two sutures to close a 4.5 centimeter laceration. It's about 2 inches. Assuming that the defendant testifies in a manner to make that incident relevant, a couple of pages of those records with the narrative of what allegedly happened and the treatment provided is sufficient to corroborate his testimony. Her testimony, sorry. Burying this, and this is, so we've got the argument that the one incident is irrelevant, and 2, the other incident is irrelevant. You can both summarize these 2 incidents in a couple of paragraphs, maybe, a couple of pages, maybe. But they're also only relevant if she somehow proves that use of self-defense is justified. But apart from all of that, and this is the one thing that tends to annoy judges, burying the jury with 550 pages of records when nearly all of them are irrelevant, when giving the defendant every benefit of the doubt on relevancy is unnecessary, and the probative value is substantially outweighed by the danger of unfair prejudice, a confusion of the issues, misleading the jury, and needless presentation of cumulative evidence. So they're saying she's had this stuff since 2022. She's had these documents. Not only are they irrelevant, but you're going to throw 550 pages of irrelevant, unnecessary, cumulative, repetitive documents regarding his behavior and things that happened that led to injuries on him on the jury. You're going to confuse them. You're going to prejudice them against him. All of this far outweighs any evidentiary value we can get out of these documents. Therefore, the state objects to these records barring their evidence being established at trial, and their probative value not being substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation. So, unless if we can show that none of these things happen, okay, but if they're not relevant, get rid of them. That's essentially what this motion says. We're objecting to them because they're not relevant. And then I certified that the copy here has been furnished to James Sylvan Owens, and there's everybody's signature and stuff. That is the new motion that just came down. It was just filed a little over 24 hours ago, about 36 hours ago. It was filed, and that's where we are on that. We looking over here at Court TV. Let's see how we're doing. Let me refresh their feed. It still says they're 5 minutes and 27 seconds away. So what should we do with these 5 minutes and 27 seconds, you might ask? Well, I think we should read another of the letters from Sarah Boon that I had previously not seen and was not aware of. And yes, Jules is in court. I've talked with her this morning, and if the schedule works out, I'm going to have her join us at the lunch break really quick to let us know what happened from inside the court. Jewel Elms with dropping the 5 Aussie bucks. This is a palate cleanser after last night's stream. Ugh. Yeah, well, we'll be revisiting that case again tomorrow as the jury selection continues in this case. So this is a break between 2 days of that. And let's see, we're ready to go, I guess so. Let's bring up this next letter from Sarah Boon. No, I do not want to save anything there. And people, 10-page Legal Vices 10-page state's response to reciprocal discovery. That if that exists, if that exists, it must have just barely gone up on the court clerk site. Okay, yeah, just dropped. Yeah, I was on the court clerk site 30 minutes ago, and it wasn't there. So yeah, and because I don't live in the United States, Florida blocks outside the U.S. IP addresses. So to get in there, I have to connect up to a VPN, which interrupts my streams. So we'll keep that on the back burner if necessary. Alrighty then. Just a quick shout out to the folks over on Rumble. And again, here we are, 741 people waiting for the trial to start, waiting for the hearing to start. It's a hearing on motions day, that probably the motion we just read and other previous motions and probably some new ones are going to be heard today. Then tomorrow, jury selection. And then the following day, I guess there will be some more, or maybe they'll do the motions tomorrow. I don't know. This is the thing that we aren't privy to what the judge is saying. So we're not sure of the schedule, and it's literally moment by moment. Court TV and Law and Crime themselves just barely put up the links to this hearing because everybody is waiting to see what the judge is going to do. So we're kind of the last to find out, but 2 hours and 45 minutes, 2 minutes and 45 seconds left until it's supposed to start. It could start right on time. It could be an hour from now. We don't know. So, well, let's begin reading this letter from Sarah Boon, shall we? We've got all the super chat stuffs are read, and we are ready to rock and roll with this new. Well, it's not new. It's a very old letter. Hey, where'd you go? There it is. It's a very old letter, but it's new to me. It's still new to me. Mr. Bankowitz, that is her former lawyer, and this is January 10th, 2023. This was to her 8th lawyer. He lasted about a year. God bless his soul. So this is from about a year ago, year and 8 months ago, a year and 9 months ago. Cool. Mr. Bankowitz. She's such see, this is a classic example of, if you look at the like and subscribe bowl, her warm and charming personality. Mr. Bankowitz, my 8th lawyer, hello and Happy New Year. I hope the holidays were lovely and very memorable for you and your family. I just wanted to check in, as I have not heard from you since the status hearing back on December 27th, 2022. So it's been like 2 weeks she hasn't heard from him. Well, about 3 weeks. She hasn't heard from him. And want to confirm you are still my attorney after your motion to withdraw was filed on 12/19/2022. It is my understanding you are, which is why I am writing. Writing to you directly, but also including Judge Wooten for fear I did not receive a response like the last almost 5 months, 21 weeks, and 147 days. It's very important to me you are aware of my questions and concerns for the anticipated pretrial conference of January 17th, 2023. So a week from the day she wrote this, I guess. It is very important to me that you are aware of my questions and concerns. I'm sure it is. If you are unable to speak to me beforehand, which I am very much hoping you will be. Now, see, here she goes again, just throwing grammar to the wind. It says exactly the opposite of what she wanted to say. If you're unable to speak to me beforehand, which I'm hoping you will be, that means I hope you are. I'm much hoping that you will be too busy to speak to me. What she wanted to say was, if you are unable to speak to me beforehand, which I very much hope you will not be. Bless her little, I excel at everything and I was valedictorian in my class and all that other stuff. Unfortunately, I am unsure. Unfortunately, I'm unsure what else to inquire about. I don't know what else I'm supposed to ask, as I am unaware of any other progress going on in my case. In the meantime, please see below, and thank you in advance for the information and clarification. What a sweetheart. See how nice she is? Thank you and please and Merry Christmas and Happy New Year and all this other cool stuff. 1 pretrial conference, Tuesday, 1/17/23. Was she homeschooled by squirrels? Oh no. Okay. I don't know why that's funny, but it is. I would like to be in attendance. What time, please? I have not received a notice via email or via mail, sorry, or heard from you to ask, and no time was stated during the status hearing. Please make the necessary arrangements for me to be included. It's my right. It's my right. It's now or never. It's my right. Boosh McFadden with the $2. Real question. I was supposed to ask. It's in DMs. Okay, well, when I get some time, I will throw open Twitter, and I will search it out. Let's click on this. I'm not seeing anything DM'd to me, so sorry about that. I see no DM'd anything. If it comes through, I will check it out, but not seeing anything in my Twitter DMs. Okay. When it's my right. Waiver of appearance. Boosh. If you want me to read something from a week ago, you're going to have to resend it. I get literally hundreds and hundreds of Twitter DMs. And there's no way I can scroll back through a week's worth of them. Send it again. Waiver of appearance. Please mail or bring the appropriate documents to unwaive my appearances going forward. They've been waived. Now I want to, all caps, unwaive them. Unwaive my appearances going forward to everything. So she waived being at these hearings before, and then at this point she wanted them all back. I want my rights. I want to go to all these hearings. So I am kept updated with any/all status of my case. It is my right. Please note, I have not signed any paperwork for you since the start of your representation, 7/11/22, as my attorney. So I am unclear how my right to appear was waived in the first place, nor have I verbally given permission for the waiver either. Please provide the signed copy at your earliest convenience. I haven't given you any authority to waive anything, and I demand that you show me the signed document where I did such. That's what she's saying with this charming, lovely personality of hers. Okay, the reason for his withdrawal. Reasons for withdrawal. Point 3. It was not made known by you as my attorney or stated by the judge to the court during the status hearing. It was not made known by you. Okay, the reasons for I hate having to parse her damn sentences. The reasons for withdrawal were not made known by you as my attorney or stated by the judge during the status hearing. Of course, it's the judge to the court. What else is he going to be the judge to? I was completely blindsided and massively confused for the attempt, as our attorney-client relationship hasn't even been established from the 2 hours we have spoken out of the now 4,536 hours. And the general information, it was actually when we actually did. And not gonna try to figure that one out. If you had genuine, legitimate concerns, I thought from a professional, moralistic standpoint, you would have discussed with me, or at least mentioned earlier, or at least mentioned rather. Her handwriting sometimes is so nice and easy to read, and sometimes so exactly the opposite. Okay, Bush, I got your question. I'll get to it in just a second here. This is cramped. It's hard for me to read, or at least mentioned rather than being uncommunicative for almost 6 months, an entire half of another year for me just sitting here with nothing to show but the perpetual question mark still over my head, just like a sad little rain cloud following her around. Sarah Boon and the sad little question mark. Sounds like that'd be a great children's book, wouldn't it? Sarah Boon and the sad little question mark. I would have hoped if you were unable to maintain your workload, which still presently includes me as your client, you would not have made the decision to take my case and even give me selling points on all your capabilities and resources. Why? Please help me understand. We are supposed to be working together and for each other rather than against. It worries me futuristic. Oh God, she loves this word. She puts the word futuristically in as many documents as she possibly can. What she means is it worries me as this matter progresses in the future, or it worries me moving forward. I just love it. It worries me futuristically. Feeling aphoristically. Worries me futuristically. Also, I have not to date received the copy of your withdrawal Judge Wooten said I was included on when reading the certificate of service during the hearing. Please send me a copy. Before we get to the phone account, let's look over here. Sylvan Gold. Sarah thinks continued equals waived. I thought about that, but there were some hearings that she didn't attend and she was bitching that she couldn't attend them. And she wanted to. So, I'm thinking that at some point she did say, no, I don't want to be in attendance at these hearings. You do it for me. And he said, okay, you've waived your appearance, but it may be a good combination of both. Who the hell knows with her, really? I mean, who honestly knows? And I'm seeing a problem with the positioning of my camera for reading super chats, but I'm doing this to see if it works better for clipping. But anyway, we'll write it out today, see how it goes. What do we got here? Yep. And Bush McFadden, it's crazy that everyone isn't on Sarah's side, right? She's so likable and lovable and smart and warm and caring and fuzzy. Now, the question that Bush McFadden asked a week ago on Twitter and somehow got lost in the process. Okay, now I can see you asked it on October 9th at 10:40 a.m. my time. What do you think of prosecutors who scheme and, oh yeah, I remember reading this. I forgot to read it. Yeah. I told you to remind me to talk about it on the stream that night, but it never happened, I guess. All right, what do you think of prosecutors who scheme and try to cheat to put away defendants they know aren't guilty? Some are pressured into the job, but it's the job, and DA has to do it. What do you think of them? I think they're scum. I think they're scum. A prosecutor that prosecutes someone they know is not guilty just to get the win is an evil scumbag, in my opinion. And very, very close to that are the ones that go, well, look, tell you what, they know they have a weak case. They know they're not going to win. They may even know the person's not guilty, but tell you what, why don't we do this plea in abeyance? Which is saying, you plead guilty, say, I did this, or, you enter your plea in abeyance, which is, okay, we do this. It's not really a guilty plea. You're saying, all right, let's yeah, all right. But you plead to it and then it's like you put it in abeyance for 6 months. And if you don't do anything bad in the next 6 months, it just goes away. It just goes away. The plea in abeyance just vanishes as if it never happened. The case just never happens. Now, the problem with that is And again, if it's in abeyance, it wouldn't be on your record, but the prosecutor still gets a win. He gets a win, and you have to suffer for it, even though you didn't do it. So those kind of, I hate, and I have a personal story about that one, which is why I think they're scum pigs. I think I've told this story before. When I was in my third year of law school, we have what's called a third year practice rule, where we're allowed to actually go to court and represent clients under the direct supervision of a licensed lawyer. It's basically like an internship. And it was one of my very first cases. This prosecutor was one of those guys. It was a textbook, absolutely textbook case of self-defense. Woman's brother's ex-girlfriend comes over to the house and decides to steal the woman's leather jacket out of the woman's brother's van. Woman comes home, sees brother's ex-girlfriend stealing her jacket. She says, "Give me back my jacket," and grabs her jacket. Ex-girlfriend swings her purse and clocks the victim in the head. Turns out that that purse had a glass bottle of Gatorade in it. Bang. So she retaliates by punching the other woman in the face. And the neighbors call the cops. The cops show up and arrest both women for battery. And this guy continued for the 6 months I was handling that case, continually trying to get her to plead guilty. And I'm like, dude, the only thing she's getting out of this case is an ulcer. She's not getting a guilty verdict because this is self-defense. Someone comes on her property, tries to steal her stuff. She tries to get it back. She's hitting the head with a Gatorade bottle and retaliates. That's self-defense. Well, you know, that's for the courts to decide. And as we got closer, the deals got sweeter and sweeter. He's trying to go, okay, look, he offered this plea in abeyance 2 days before a trial. And the jury's already been summoned. They've all got their letters. They're supposed to show up. They're supposed to call the night before to make sure it's still going forward. And he says, "Oh, let's do this plea in abeyance." She enters a plea in abeyance. We hold it in abeyance for 6 months. Then it goes away after 6 months. I'm like, well, hell no, she's not going to get up on the stand and say she did something that she didn't do. He's, "All right, we'll see you in court." The night before trial, he called and tried to do the same thing. Well, let's just do this. We'll do plea in abeyance, but we'll do it for like a lesser period of time. I can't remember what the lesser period of time was. And it was something that was equally stupid. I said, I'll tell you what's going to happen. Tomorrow, we're going to go into that courtroom and a third-year law student is going to open his criminal law textbook and start reading from the first paragraph of the first page on the chapter of self-defense. And you are going to look like a fool. If you want to go through with this, let's do it. He called 2 hours before the trial and said he was dropping the charges. 2 hours before trial. Judge was pissed. Jurors were unhappy because they'd called the night before and heard it was still on. So they were all making their way to the courthouse and they got there and they didn't need to be there. And this guy had the balls to later come back and go, I'm wondering if your former client, if you could get a hold of her and see if she would be willing to testify for us against the other woman. And I'm like, okay, I'll tell her. She wanted the other girl to be punished and go to jail, but she's like, hell no. If the prosecution wants me, the way they treated me, screw them. She was willing to let this woman that clocked her in the head with the Gatorade bottle walk just to avoid a situation where the prosecutor got a win on that case. So hats off to that woman. She literally let her attacker's case go away just so that jackass of a prosecutor wouldn't get a win. So I thought that was pretty amusing. But yeah, that was one of my few criminal cases that I handled back in the old law school days. And I did have another guy. This was a police officer. Oh, I forgot to tell you the most important thing. It was the night before. This is the direct answer to Bush's question. The night before when the guy was trying to give this super sweet deal, I said I said I was going to walk him through the evidence, the criminal law book. He said, "Well, look, we'll go to court because if I'm not going to prosecute her, I'm going to be prosecuting someone else anyway." I'm like, I don't think that's how this is supposed to work, pal. If you're not in court with her, you're going to be in court with someone else, so you may as well be in court with her. And that started to kind of sour me. And there was another case where it was in front of a justice of the peace, which she had no legal training. It was essentially like glorified traffic court with a cop that couldn't find north on a map. Literally, he drew the map and didn't know which way north was. I don't know how I lost that case, other than the justice of the peace was just dumber than a bucket of rocks. But afterwards, he came up to me and said, "Hey, no hard feelings. That's just the way we play the game." I said, "Yeah, this ain't a game to my client, you know. It's not a real game to him." So yeah, these kinds of prosecutors that just want to get that win, even if it's not a straight jury verdict, if they can somehow convince you it's good to take a plea deal or a plea in abeyance or something like that, and they know, or they have every reason to believe your client didn't do it, absolute scum. I hate him. So yeah, those are my two of my decently bad stories. Like, literally, I don't have any good stories from my time. Okay, I did have one funny case, but now isn't the deal. There was one funny case, and everything else involved a crappy prosecutor. Now that I think about it, oh god. Anyway, that was a very long answer to your question, Booth. But still, we're waiting for the court to do something. So, right. Let's see. Oh, we've got Aussie Overlord here has dropped a big $5 Australian Korean message to us. 읽지마세요. 제가 제출된 세 가지 소리 보냈습니다. 알아서 하세요. That's actually a pretty good. I would say that was either a Grok or a Chat GPT translation. I can kind of tell which, and I would bet on Chat GPT. I can kind of tell how they translate things. It says, "Don't read this. I sent you." See the previous 3 documents. Do what you want with them. Thank you for that, Hayden. IT Goatee Brad, what's up? Sent you a link to the docs in Twitter. That's kind of what Hayden just said, but in Korean. Thank you so much, IT Goatee. And Island emailed today's doc drops. Oh, you all are just loving me. You're all just loving me. Thank you so much for the drop. How close are we to doggos? We're about 30 away. We're about 30 away from unleashing the emotional support potato pig dogs. All right, let's get back to this. Let's get back to this letter, shall we? And then we'll continue as necessary. People over in Law and Crimes chat are getting restless. They're all panicking that there's a plea deal going on or something. There's a plea negotiation going on. That would suck. Uh-oh. Oh, phew. Jules just scared the crap out of me. Not for... She said, "Late start, judge is still dealing with plea deals." And I had a little minor heart attack there. But continuing to read the sentence was, "Judge is still dealing with plea deals for other prisoners." Whew. Okay, gave me a little heart attack there. That gave me such a heart attack that I think it's time to have a nice, delicious drink of the official Sarah Boon cocktail, the Boone Tang Suitcase. A delicious combination of tang and vodka. The Boone Tang Suitcase. Delicious. All right, let's get back to this letter, shall we? I love how that would sound like a sponsorship, and there's like nothing being sponsored other than me making silly, childish 12-year-old jokes. Okay, phone account. She wants a phone account, I guess. This has been a constant request for her. It was previously told to me by you in our in-person meeting on 8/22/22 that you already had this set up and were having your assistant look into it so we could use. After not answering any of my calls, the few I did make in an attempt to touch base with you to provide requested information you asked me for, I stopped calling you Mr. Berkowitz. Mr. Bankowitz. I'm saying, well, dang it. She for excelling at everything she does, she sure sucks at grammar. Punctuation. I stopped calling you, comma, Mr. Bankowitz, comma, and have not to date since September 2022. Not I've stopped calling you Mr. Bankowitz. What should you call him now? I kept hoping you would call me or set up a visit, even for 15 minutes, which has not happened. Please help me. Help me, Mr. Bankowitz. You're my only hope. Please help me understand why you gave me your personal cell number. Also, to clarify for you, the judge, etc., I did not avidly search for the statements regarding your public reprimands. Oh no, she went digging for his disciplinary records. Oh no. Oh, Sarah, he's not calling me. He's not answering my calls. So I'm going to go look for his public reprimands. She says she definitely did not do that. I did not avidly search for the statements regarding your public reprimands in 2015 and 2018 in an attempt to speak with you. From no response to my letters or calls, seller office, when having someone look up any contact alternative and to confirm your address from a letter I sent that was returned, then resent, the reprimands were discovered. And for the same complaint as mine, lack of communication. Was it lack of conviction? So apparently he was publicly reprimanded in 2015 and 2018 for lack of communication. During the status hearing, when I made this known, I was not clear in the end if you were going to actually set up again the phone account to be used, which any and all callers, inmates, must have established in order to speak to family, friends, attorneys, anyone. It is nothing new or extra, and all costs incurred can be submitted for payment to the court, as you have done in the past already. This is how attorneys communicate with their clients here in OCCD. Well, this is how, let me tell you, as a current inmate, this is how we do business around here, partner. This is how we do business around here in the OCCD, the Orange County Corrections Department. Another option, in addition to 45-minute video visits, 15-minute at-home visits, in-person visits, and, of course, the Postal Service. You need a B. There's no B verb there. Anyway, it would definitely make sense to use in avoidance of even more time, being exhausted in the length between any visits in the future, which will only help the progress of everything. Will you be utilizing? What is the object of that sentence? What is the object? Utilizing what? So basically says we can do 45-minute video visits, 15, I don't know what this 15-minute at-home visit. I have no idea what that means. In-person visits, Postal Service, just get a hold of me some way. Discovery and case materials. In the status hearing, you stay. Oh, we did have a couple of super chats over here I wanted to discuss. The Polish drunk, good morning from Utah County. Well, good morning to you there in Utah County. Good to see you. Thank you very much, my fellow Utahn. Good to see you here. And Canonical Heat just dropped another $20 super chat saying, release the hounds. Ooh, you know what? That's pretty darn tempting. That's pretty darn tempting. Because I just give me 1 second. Sibling Creature is a new member. Sibling Creature has just joined as the newest member of the Clean and Sober crew. Thank you so much, Sibling Creature. And Starry Eyes with the $2. Release the hounds. Well, I just have to let you know that Thank you to all of you. Thank you to all 935 people here waiting for the trial, waiting for the hearing to get underway. 935 people. We got 500 likes. Literally 400 of you. Almost half of you haven't done your job. While we're doing this, get down there and smash that like button for me. Do me a big old favor, please. And hit that like button and subscribe if you haven't. We're inching our way up to 81,100 subscribers. But now, due to the generosity of all of you, due to the wonderful people we have here, we have for the 36th day in a row, ladies and gentlemen, we have reached that part of the show, which for the 36th day, we're on day 35. We've reached it for 35 days. Now it is 36th. For the 36th day in a row, we have got to that part of the show, which we call Release the Hose. And we introduce to the stage our emotional support potato pig dogs for the evening to help us get through the emotional difficulties of the Sarah Boon and other legal proceedings. This is Strawberry, one of the emotional support potato pig dogs. The other one is Yoda. There's Yoda over there. So Strawberry and over here. What's up, Strawbs? And they're such good little pig dogs. I brought them treats, but I can't seem to find out where I put the treats. I swear I brought them little treats, but I can't find them. Aha, there's the treats. But Yoda's asleep, so Yoda doesn't get one. Yoda's dumb. Here you go, Strong. Have a little treat. Yoda. There's a treat on Yoda's back. Yoda, hey. Yoda. Hey. Yoda is dumb. Yoda, hey. Yoda, hey. Yoda. There you go. Oh, he smells it. It's right there, dumbass. All right, we'll see how long it takes him to find. Oh, there he goes. He's got it. Yoda's not the brightest, even by English bulldog standards. Yoda is not the brightest English bulldog in the shed there. All right, thank you so much, everybody, for unleashing the emotional support potato pig dog cam for day 36. We can get rid of this measly 35 number, and we'll see what happens tomorrow. Checking back in. Nope. Law and Crime is still not starting the hearing. We're keeping an eye on it. And as our in the court reporter, Jules, has said, they're still dealing with the other cases, with plea deals for other prisoners. So as soon as there's any development, we will let you know. But in the meantime, we're going to continue with our reading of Sarah Boon's letter. And then after that, we'll go and look at these new filings that just dropped mere moments ago. All right. Oh, how are we going to do this with the dogs? That just covers up like the entire damn screen. Can we do that? Nope. Doesn't do any good. That's not smaller. Oh, that looks terrible. All right, let's go back to the old way. There we go. Right. That's what we're doing then. Discovery case materials. And thank you everybody that's hitting that like button, by the way. Deeply, deeply appreciate it. That gets the word out there to YouTube, and they go, hey, something interesting's happening. And they send people our way, which is what we're after. So thanks a lot. Appreciate it. You guys rock. We're up to almost 600 now. All right, discovery and case materials. In the status hearing, you stated that you have 2 boxes of information that are out of order and unorganized. Dog belch. Have you organized and reviewed? How long have they been in your possession? Oh, see, this is rich coming from the woman who obtained George's medical records in 2022 and only just delivered them to the defense to the prosecution 2 days ago. Come on. That's rich. Have you organized and reviewed? How long have they been in your possession? When will we be going over? It is extremely concerning. This is all you have. It has been said there were 3, 5, 6, a ton from some of the attorneys prior on my case. Which is it? And what is there? She asked snarkily. Which is it? And what is there? 3 years later, I'm still wondering. I have also put numerous hours, pages, pen ink of my own information, which I am praying is in either of the boxes you currently have. Please let me know. As the Now added as the added amount, literally her A's and D's look the same, as the added amount of even more time to locate, receive, review anything missing from everyone receiving before then withdrawing will most definitely be extreme. If you say so, I'm not even really sure what that meant, Sarah, but good for you. I don't know what you have. I can also assist in organizing what you do have, considering it's part of my case. I'm eagerly awaiting and more than willing to help with this and everything else. I just need to see what there is, which I have yet to 3 years later. Prosecutor. Is there a new one in my case? There's so many lawyers on all sides. It's just hard to keep track of them all. Is there a new one in my case? I noticed his attendance during the 3 status hearing attempts. Okay, so this 3 status hearing attempts, that sort of leads credence to the super chat a little earlier that was saying she may be confusing continuances with waivers of appearance. That kind of leads some credence to that theory there. I noticed his attendance during the 3 status hearing attempts and came to the conclusion there is, since you have not communicated with me this or any information, nor an announcement made by the court, I do not know. If so, what is his name? What is his background? Oh, I bet his background is he's a lawyer and went to law school and then became a prosecutor. I would guess. That's just a theory I have. I don't know who she's talking about, but that's just a wild guess. Mr. Bankowitz, you must understand how insignificant I have been made to feel with the never-ending debacles, hurdles, and stumbling blocks. She could build Fort Brooks out of hurdles, debacles, and stumbling blocks. I have and am going through and still facing since becoming incarcerated. No one seems to listen, ever. I refuse, absolutely refuse to believe this. My entire experience to date really is how our justice system operates. I refuse because, as said to you, Judge Wooten, the court, to everyone else in the status hearing, and to anyone who truly cares, my reason is hope. Never ending, no matter what. Hope. This being the entire reason I am even here for my incarceration. Nothing is impossible. With God, nothing is impossible. And I await my day to say my truth. That's a trigger for me. Absolutely hate the term my truth. There is the truth. There's your interpretation of the truth, but that does not make it your truth. I hate that phrase, my truth. Ugh. Okay, your side of everything. Okay, I'll give you that. I wait my day to say my side of everything. Perfect. Great. Good for you. But to say my truth, no. Uh-oh, we just had a flash from... looks like Law and Crime has moved from the warm-up screen to the clock. But, right? No, it's just staying on the clock. Please don't give up. I have not and will not ever. I await your response as always, Mr. Bankowitz. Mr. Bankowitz, thank you. Sincerely, Sarah Boon. And there's her mailing envelope. And that's the end of her letter. Let's check in on Court TV here so you can all see what it is that I'm seeing. This is what we're looking at. Exciting, isn't it? The clock. That's what we're looking at here. But before it was just, what do we got going here? Oh, Sarah Boon coming into court. Oh, she's got a sensible business suit on there today. Little business skirt. Sort of looks like probably what the corrections officer looks like. You know, the not that corrections officer, obviously, being like the matron of the prison, assuming it's a woman. Unchain my heart. Unchaining Sarah Boon. Sarah Boon, unchained. Now they'll set her there, hide the pink cuffs. And ladies and gentlemen, we're getting down to business. Lynn Britton, member for 4 months, who is Doggy's representation. You, sir, are disparaging their reputations. Save Yoda's rep. I wish I was being very nice to Yoda. If I told you the truth of how of how unintelligent that dog is. You would think I hated him, but I love him because he's stupid. He's a special kind of stupid. If Sarah wants snacks, they should just put a popcorn machine in there for everyone. Oh man, I would be all over I am such a popcorn honk. I love popcorn. And I was kind of sad yesterday because I made some popcorn to eat, and it's been raining here for a few days. I made the popcorn, put it on the shelf, went to do something. It took about 10 minutes. I came back and the popcorn was already soggy, and it was just terrible. But none of you asked about my popcorn habits. I just love popcorn. Oh, Sarah's smiling, and she's her hair got she done did her hair again. Her hair got did. That's good. Let's prepare. All right, we're in court now, so we can do this. We don't have to read documents. Oh, what's happening, Sarah? Is that too big? That's probably going to be too big, but we'll see. We'll ensmallen it if we have to. Oh, the quietude of it all. Let's do it. Come on, people. You can cut the tension with a knife, at least here in the room. At least here in my room. Adjust the stash. She looks nice. She looks very, very presentable. A little ruffled collar that gives you kind of that nun look. That's a good look. But the jury's not there, so she could have just wore her prison garb, but it'd be funny if they were like talking about important stuff and just it was somehow muted. Do we have? All right. I wish we had a rip leader, a rip leader, a lip reader. What the hell is a rip leader? With no ho-hos and Twinkies. Yeah, I don't know what this is all about, but I've had several people say that she's made some sort of request for free snacks being provided. Is that true? Is that like a real thing? She asked for what reasonable snacks to be provided. I really haven't heard that. Gosh, she doesn't look like a murderer, eh? She just asked for water. Okay. Oh, an island with a $2 super jet. You can pop amaranth like teeny tiny popcorn. Tastes a little different. I guess you can do it with cardamom too, but I'll just stick with popcorn. I have no idea, but I wouldn't be surprised if she did. Enough people have said it independently that I think it might be a thing. I saw something about her having to get up at 2:30 and she needed snacks or something. It could be. Yeah, she did say she has to get up at 2 a.m. so she can be there. It takes a lot to get a prisoner to court. It really, really does. And it's just something you got to do. My banner is still on. Well, we're still waiting for it to start, in case someone thought we were muted or something. But I'd forgotten about it, so I was just trying to make it look like I did it. Now I'm doing it intentionally, but before I forgot about it. So here we are. Let's go. LFG, man. I wonder if the lawyer to the left is going to sound just like he did on the conference call through Zoom member static. Oh, that's right. He was the one on the Zoom call, wasn't he? Where he just wouldn't stop talking. Yeah. He had like the way overblown microphone. It was echoing, it was crackling, and he wasn't stopping for nobody's business. Can your lawyer give you snacks? Well, they would have to be, generally no. But you can get permission, things like that. Because, you never know what could be smuggled inside the jelly beans. I mean, snacking at the defense table is not generally something you want to be doing. But Johnny Depp had snacks. He had like jelly beans. I think Karen Reed munched on chocolate a few times. Let's talk trivia. Rob says, Jeff, there's no crying in baseball and there's no snacks in the courtroom. What are they thinking? And again, a super special shout out to the 1,017 people that are watching this. We have 606 likes. We've bumped over the 600 likes, but there's 1,100 people here. There's really no reason that we don't have 1,100 likes. Just saying. And please feel free to hit that subscribe button. We currently have 81,050 subscribers. We could easily get to 81,100. Just 50 subscribers. We could get there this fast because I know there's at least 50 of you watching right now that haven't subscribed to the channel. Oh, she's confused. Whose water is this? Oh,
William J. for the state.
Let's effing go.
James Owens on behalf of Sarah Boon. Tony Henderson on behalf of Sarah Boon.
Oh, she's getting in now.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion objection and motion in limine to exclude decedent's medical records filed October 14th, and then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed.
Okay, how is my audio? Is my audio
proceed first on
a
the
lot louder?
Spouse
just a little bit louder, or
first. So state
it should be a little. It should be slightly
and
louder.
I
than
also
him.
have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
All right. Great. Thanks, guys. Appreciate you letting me know. I did something right for a change. All right, let me put up a banner telling people what's going on here, and I'll try not to be shouty. But I get animated sometimes. You'll have to forgive me. All right, they're going to argue these motions, and should be good. We'll see what's happening. Everybody's typing. I'm typing. They're typing. Everybody's typing. All right. And we are live, ladies and germs. Boom. I've been waiting for this for 2 years. That's crazy. But I mean, whereas it's crazy we've been waiting for 2 years for this, we've been waiting almost 3 years for Courtney Clenny, the OnlyFans model that allegedly murdered her boyfriend. YNW Melly, he had his hearing ended in a mistrial a year and a few months ago, and he's not scheduled for a retrial until September of next year.
I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit. As to
Jury selection is not done. It's going to take another day or two.
Review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes, in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire. Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides,
Again.
we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. we're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but two fingertips could get out. Mind you, a 103-pound man, two fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm.
Doesn't sound much like a battered woman, does it?
She just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get two fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence.
What on earth is that?
Or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
All right, the response is going to be the interesting part. How is he going to respond to that? She hasn't established that anything bad really occurred other than what she did to him at that point in time. And for those of you asking, I'm sorry.
I'm a little confused, but I want to make sure. So,
don't say that.
Save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Okay, while he's conferring, we had a question here. So the state has to know what the defendant is going to say on the stand beforehand. It depends if they're making a defense like self-defense or battered spouse syndrome, because that shifts the burden to the prosecution to prove that it didn't happen. If they're allowed to make a self-defense argument, if they're allowed to make a battered spouse argument, so they have to give a notice, and they gave their notice.
Sure. So my understanding, well, let me ask, I'll ask a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's mental health situation. I mean, a person
He sounds so
doesn't
totally
really know
unprepared.
that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told an outside sources too. They are able to make a determination based on their training and experience. So,
But based on
Yes.
the
What is she going to testify
Kendo
to?
case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of
There
fear.
must be an overt act that
And she was
to
unable
put someone
to
in
answer those
immediate
questions.
fear. What was that act?
So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case.
What?
But
Exactly.
it has to be the testimony
What is
of
it?
Sarah Boon for that overt act.
What
And that
is-
testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely
Yeah.
agree with you on
But
that.
what is she
And the
gonna
case law is
say?
clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
It's a basic question, dude.
Procedurally, there's no way that we could come in here and put Dr. Harper on the stand before Sarah Boon. It just doesn't work, because to even establish the relevancy of Dr. Harper's testimony, Sarah Boon, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial.
Oh my gosh, I want to yell at this guy.
Because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boon. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boon takes place at trial. This is just procedurally incorrect.
Any other argument, sir?
No other argument.
Thank you. Rebuttal?
How do you rebut something that was never said? That was weird.
Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boon made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouses.
I wish I could
There has
drink
to be an
Chardonnay with
overt
my
act.
dog.
You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Oh, I completely agree with him. They can't even say what the overt act was that triggered
Briefly.
Ooh. He's begrudging him a re-rebuttal?
Judges,
Sir
it's not the
rebuttal.
responsibility of the defense to present their case at a pretrial.
Kind of is in this case.
However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act. Yeah. And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge. But
then what is it?
Myself in the position now to disclose.
Yes, you have to.
Our view of the overt act is.
You have to.
That's what this has put. This is what this motion has put us into. So it's an exercise of the state to learn our theory,
yes,
or our view of the evidence, because
you're putting on an affirmative defense. They have to rebut.
And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now,
clearly,
based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act.
The overt act is her whacking him with a baseball bat in the hand.
You don't have to wait for them to pull the trigger.
Fuck.
You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir.
What the hell was that?
The opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279. No argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110. Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724. State v. Woodson, 349 Southern 3rd, 510. And Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
you want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
my concern is open. Can it be mentioned in the?
Yes.
He said
That's
yes.
your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you.
All right, I'm going to pause this real quick here and just sort of give a really quick summary of his decision. They wanted either to completely throw out the possibility they could raise the battered spouse syndrome. He rejected that part of the state's motion, but they said, okay, at least make somebody give some testimony about what overt act caused her to be imminent fear. To cause her to be in fear of imminent bodily harm or death. And he accepted that part. He said, before they can call their expert testimony, before they can call their expert witness, they need to be some evidence of an overt act. Only after they provide evidence of an overt act that would have put her in fear of imminent bodily harm or death are they going to be able to put their expert witness on the stand to say that that act would have triggered whatever battered spouse syndrome was there and justified her actions. This is exactly how I would have ruled on this.
Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
All right, and again, really quick, just stopping this here for those of you that may not know what they're talking about. The defense wanted certain things from her second police interrogation, the one that took place in the sheriff's office, excluded. One was a discussion about the neighbors and not letting her use the bathroom or whatnot. They said that was irrelevant. The state said, okay, we agree, that's irrelevant. We can get rid of that. But they also wanted these statements like, you killed him, you're responsible for his death. These statements that the detectives made, the defense wanted to exclude them as being improper and prejudicial and whatnot. But the state argued, no, they have to be kept in because those statements were given by the investigating detectives specifically to elicit certain responses from her. And they did elicit responses. So therefore they should be kept in. And that's what they're arguing here now. And very, very good. Duncan Idaho, the $5 says, I feel like I'd be pretty PO'd at this point that Sarah Boon didn't plead out if I were Owens. There's just no way that a jury will be sympathetic. I think he knows that. And that's what he tried to do. And it didn't work. And Sibling Creature said, oddly enough, I have experience with this. Thank you so much for the Aussie $20. As a child, I once zipped myself into a Duna cover until I could only fit 2 fingers through the opening. It was very difficult to open the zip and I had room to move. Yeah, they're not designed to be opened by a pulling of a finger. In fact, they're designed to lock and prevent that in most zippers. Thank you very much, Sibling Creature. And Duncan Idaho also said, I have the feeling that he knows all this, Jeff, but he had to be stubborn and hang on to the sinking argument for dear life. I don't think that defense lawyer was prepared for that. He sounded horribly out of his depth. I felt pity for the guy. I really don't think he was acting there. And Tanny Simmons, the member for 4 months, says, don't you effing tease that dog with the Boone tang, Jeff. Okay, I won't. All right, let's go.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state.
Hey, how about we use the microphone, guys? What do you say?
I said there's no state witnesses.
So that's a no.
Getting
Maybe proceed
testy.
with any argument, Mr. Owens. Yes, sir.
Oh, wow. I missed stuff back there, guys. I apologize, like from a long time ago. Starry Eyes gifted 5 Legal Vices memberships. Island gifted 1 Legal Vices membership. Sonny or Chris gifted 5 Legal Vices memberships. And Sibling Creature gifted 5 Legal Vices memberships. And at the beginning, I know we mentioned that Canonical Heat gifted 10 Legal Vices memberships. So I apologize for missing those. And Sibling Creature has also become a new member. I really, really apologize for missing those. So if any of you got any of these gifted Legal Vices memberships, just give a general thanks to whoever may have given it to you. I thank you so much, guys. I did not intentionally ignore that. I don't know how I missed it, but thanks.
I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And
anything else?
The day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boon had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found. Do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boon refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolve you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree.
Okay, well, the Jackson case speaks for itself. The court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this in this expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to
All right, that's fair enough.
the
No problems with that. It's not fatal one way or the other.
state's objection and motion in limine to exclude decedent's medical records.
This is the one
I've
we read
reviewed that
earlier
as
today.
well. State, you may proceed.
This is what we read earlier today, this motion to get George's medical records excluded from
Just
evidence.
the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018. Third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boon that Sarah Boon said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018.
Whatever she ends up testifying to.
But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that.
And as we read earlier, he got beat up so
I
badly
don't
he
know
needed
that
facial
487
reconstructive
pages
surgery
need to
after it.
corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records, generally, I would say in this particular instance,
Malcolm,
a
yes.
handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Let Owens
Judge,
talk.
As you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that has been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the court
I
Yeah.
right
understand
now.
that.
Different.
But yes. The medical
And
records
because
have
they
been
did it, we
narrowed
get to do
down.
it is not a valid
Yes,
argument.
we would have to make some tie to Sarah Boon's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you?
No.
All right, well, we
And
took the
she's had them for
deposition
2
of
years.
Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here.
Uh-oh.
I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boon's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today,
Oh,
Judge.
that's what today is for.
We'll talk in the next couple of days.
Today
My position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have to look
window.
at the records, but there is other
0.31?
evidence in those
Is he
records
alive?
that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boon, depending on
Oh,
what her
come on.
testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
Yeah.
I don't know what else to tell you, Judge.
Tell him what he wants to know.
She's going to have to testify, and then we'll make the arguments.
And what is she going to testify to?
I'm struggling with understanding how I can understand BAC results.
Yes.
I can understand that
Yes.
based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017?
What are you doing?
How is it relevant?
Some of those may not be. Some of the records.
Well,
may be,
get rid of the stuff
depending
that's
on
not.
Sarah Boon's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's the bad argument.
Response?
So basically what he's saying is it's relevant and needs to come in because he got beaten by his brother so badly that he needed facial reconstruction surgery because Sarah previously mentioned to his brother that he had laid hands on her. So they want all these medical shit to come in so that they can say, okay, this came in because this happened because he laid hands on her in the past. I don't think the judge is going to go for it.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired
They were
years
where?
ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window.
That's like
On
borderline
that date,
dead.
Again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to
I think that was a fair ruling. I got no problem. This judge is really good.
The evidence. Give me a moment.
All right. Well, he's taking a moment here. We will
We
also
have the
take a
defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
All right, before he proceeds further with this, I want to catch up on a few things here, make a few comments. Where are we? Oh, Sarah had her hand up at the beginning. I think we forgot to mention this as well. Had her hand up at the beginning, like stop in the name of love when she was being sworn in at the beginning. Thank you very much, Canonical Heat, for being a member for 2 months. Thank you so very much. Duncan Idaho says, rolling for Gracie. Okay. And Duncan Idaho also gifted 1 Legal Vices membership. Thank you so very much. Now, a lot of you made this comment. Well, first of all, JKD Buck says, we're not going to get the opening arguments, are we today? No. So he said they hope to have the jury impaneled by tomorrow. There might be some additional stuff that has to be discussed before they start. Apparently, they're looking at probably Thursday before we get to opening statements. We just have to play it by ear. The judge will hopefully let us know what the schedule is by the end of this hearing. We'll just have to see, but we're not getting anywhere near opening statements today or probably tomorrow. And these three comments, I just want to make a little blanket statement here. I'm uncomfortably blocked. Hang on. We need to see my handsome mug there. There we go. Oh, what do you want, doggo? That's strawberry. Hush. Anyway, I undermeant what you said you chose to take the case. And Katie says, yikes, it's clear this guy is a crappy attorney who just wanted to take the case to get publicity. And Special KL says, ugh, Owens is horrific. I would respectfully disagree with the three of you and everybody else that was saying. There was a lot of people saying that. I think this guy's a hero. Owens is a legitimate legal hero in my view. Sarah is entitled. She's entitled to have someone speak for her. She, unfortunately, through her own actions, was made it so that she was no longer able to get a public defender on the public's dime to be her lawyer. But still, if she represents herself, you can't really call this justice. It would be a laughing stock. It would be a joke for all of us. But she's a person just like you and me and everyone else. If we're accused, we want to have a lawyer represent us. We want to have someone who will vigorously and aggressively argue on our behalf. And he is the only lawyer in the state of Florida, in the entire state of Florida, that came forward and said, I'll tell you what, I'll take her case. I will represent her. I will be her advocate. I will ensure that her rights are protected and she has competent legal counsel in this case. He's the only one that would stand. Not a single other lawyer in all of Florida would say, look, I want to make sure that her, even though she may be guilty, even though she may be not the most reasonable person, she is still entitled to have someone speak on her behalf and ensure her rights are protected. And he's standing up and he's doing that. He's making these arguments, which all of us, I think all of us in chat tend to agree, are not the greatest legal arguments, but that's all he's got to work with. Dude's got nothing to work with. He's doing the absolute best that he can with what he's been given. As Bush McFadden says, I don't think this defense attorney is a bad person. Not at all. He's struggling. He had a bad case and he's trying, goddammit. Exactly. He's trying. He's doing the best he can with what he's got to work with. And he found two or three other people to join him that would be willing to take the case after he took it. So I don't think he's this is getting publicity for representing her is not the best kind of publicity you want. It really isn't. Saying I was the lawyer that represented Sarah Boon in this horrible case that is seemingly hopeless. Not the best PR, not the kind of PR you want. But anyway, I just wanted to address that real quickly because I respectfully disagree with those statements that he's a bad guy, he's a publicity hound, whatnot. There are many other cases he could take that would give him much better publicity than this. And God bless him, he stood up and he said, all right, for what it's worth, I'll do it. And if you recall, originally when he first took this case, he temporarily took this case for the purpose of arranging a plea deal for her. They got in a big fight. He said, she apparently said, I don't want to take a plea deal. And he said, all right, I can't represent you. I was just here to try to get you a good deal. You don't want it, I'm out. And then she called and said, come on, I want you back. And that's why I think the guy's a good guy. Anyway, all right, let's get on with this. Enough of that.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
All right, the judge needs a minute. Let's see if we have anything to comment here.
All right.
Oh, never mind. That was short.
I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return.
Oh, great. So now the whole pool is going to get COVID.
551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that float.
I understand they had 13 potential jurors. Now, if that's correct, they're down to 11.
Other juror 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today.
Okay, 12.
So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor.
Oh,
The
okay.
deputies have already brought in additional chairs so that we can fit 53 people in here.
All right,
That's
so
the
now they
only
have
other
53
housekeeping matters
left.
that I have to address.
So, and then they'll whittle it down to 6 plus however many
Are there any
alternates they have.
housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when 2 of these panels, or at least one of these panels, has already been exposed to COVID up in the 25th floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second?
Oh my God, if this case gets delayed 2 more weeks because everybody's got COVID, I'm going to lose my shit. I'm sorry, I'm going to lose it. No. Just put them in the big courtroom. Why not? Yes, Antoinette Kilpatrick says they have 54 potentials, now 53. The state will voir dire this afternoon. The defense tomorrow morning. Judge wants 16 jurors? So that's like 6 plus 10 alternates? Because I know Florida generally does 6 for non-capital cases. So he wants 6 and 10 alternates? Or how many, do we know how many jurors he's going to sit? I assume it's 6. Huh. All right. Well, interesting. I'm going to scroll back through a couple things here and see what we've got going. Will Call Magic a long time ago said, take the plea, Sarah, take the plea. There is, as I understand it, there is not a plea deal on the table. They offered it. She rejected it. They said, okay, done. I don't think it was an open-ended, I can accept it anytime I want plea deal. So yeah, there's no plea. As far as I understand, there are no plea offers on the table at this point. And CHD says legal advice of the fact sheet didn't take any plea deals with all this evidence is mind-bending to me. We hypothesized about that a week or so ago. I firmly believe that she believes she's innocent. I don't think she's playing 3 or 4D, even 3D chess. I don't think she's playing 4D chess with anybody, let alone 3D. I think she honestly believes that if she's given the opportunity to explain the way things really are, that the jury will go, oh, well, yeah, we see. Well, you're not guilty. And they'll send her on her way. I think she honestly believes that. So she's like, I'm not guilty. I'm not going to take a plea deal. I just need to let them hear my side of the story and they'll all come around. It's crazy talk to me, but I think she honestly believes that. She's playing 0.5.
All right, court's going to take a 15-minute recess to address jury selection location this afternoon, and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection. Well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Huh. Well, this is interesting because when are they taking lunch? It's now 11:30 there, so maybe they'll take the lunch around I don't know, 1 p.m. Anyway, all right. Well, while they're doing this, we are going to go and read through some of the motions. Because there was these 3 additional documents that were just dropped right before we went live today. So we've got 3 things. Let me just open these real quick. And while I'm doing that, while I'm opening these 3 documents, we have 1,187 people here and 875 likes. That is so freaking awesome. Let's get us up to 1,000 likes. Come on, we can easily do 1,000 likes. That is not a problem. And please hit the subscribe button as well, because currently we have, oh my Lord. Okay, I just got surprised a little bit. We have 81,144 subscribers. We've picked up 104 subscribers since we started this stream. Thank you so very much for that, people. You guys are fantastic. Keep those subscriptions coming. Let's get us to 82,000. I wonder if we can get to 82,000 before the end of the, I wanted to get to 81,000 before the end of the trial. We got there before the start of the trial. Let's see if we can get to 82,000 by the end of this trial. You know, you want to do, okay, we're at 917 likes. I sound like an auctioneer, but we also have our like and subscribe poll. So once you do hit the like button, once you do hit the subscribe button, and if you are subscribed, just double check to make sure you're still subscribed and take our like and subscribe poll. What is Sarah's greatest strength? Our choices today, 10% of you say Sarah's greatest strength is she works well with others. 14% of you say that Sarah's greatest strength is her warm and charming personality. 30% of you, almost 1/3 of you, say Sarah's greatest strength is that she excels at everything she does. And you know how we know she excels at everything she does? She told us. And 46% of you, nearly half of you, say her greatest strength is her ability to create new words. My favorite Sarah Boon new word is, futuristically? Anytime she wants to talk about something in the future, she says it's taking place futuristically. I love the word futuristically. All right, that is our like and subscribe poll. It's just a silly little gimmick to remind you to hit like and subscribe. But thank you very much for that. And we've only got 70 more to get to 1,000 likes. Freaking awesome. Real quick here, let me bring these three things up. Sarah Boon. I got to go to the Sarah Boon file. The Boone file. What are we looking at here? 41, 42, and 43 documents. It didn't open document number 43. Hang tight. There we go. Got him. What we've got here is a 3-page defendant's amended response to state's motion in limine to exclude battered spouse syndrome. A 3-page response. The defendant's response to state's motion to exclude. It's the same document. No, they're slightly different. They're the same document, just the title has been changed. So I guess we only have 2 documents to get through. And the state's response to defendant's 5th amended reciprocal discovery exhibit list. That's 10 pages. We'll do that one second. We'll start off with whichever one of these was filed most recently. 310. That was filed on October 15th at 9:15 a.m. October 15th at 10:03 p.m. All right. So they filed their response, then they filed an amended response. Got it. All right, I'm all caught up on these. These are documents that were just emailed me by a large number of you. All right. So we've got that. Let's bring this up here. And let's see, we're on the 15-minute break, so we'll do what we can during the 15-minute break. And Brian Miller, who's been a member for 15 months. That's almost a year and a half, brother. Thank you so much, Brian. Let's see if Jeff can get to 100,000 K before Melly retrial. We're a year out. Well, 11 months out from the scheduled start. It's scheduled for we're a year out. It's scheduled, I believe, like nearly September 25th of 2025, somewhere around that day. But Melly retrial will happen, even though it's a billion years late. All right, we are going to present this screen. So let's stop the court feed and bring up the Winder over here. Is that the one we want? I think that's the one we want. This is where we will start today's festivities. Let me swap out the view. There we go. And that's not the one we definitely want this view or this view. Yeah, we want this view, right? And we'll embiggen it so that we can see it as large as we possibly want. Is that too big? That is too big. There we go. Okay, we're going to do this until the court comes back. I'm monitoring the law and crime feed, and we'll go back to them as soon as possible. But first, this was just dropped. It was just docketed a few minutes before we started. So about 12 hours ago, 13 hours ago. Defendant's amended response to state's motion in limine to exclude battered spouse syndrome. Again, they said they haven't proven, they haven't given us the imminent act. They haven't given us this overt act that created this imminent fear of bodily harm or death. And this is the state's response to that motion in limine. Comes now, this is the magic religious wording. This is the magic courtroom word we have to read. Comes now the defendant by and through the undersigned attorney and states the following. Ding, 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 ding. Incense, holy water. There we go. Introduction. On September 20th, 2024, a month ago, this court found defendant's notice and amended notice of intent to rely on battered spouse defense complied with the Florida Rules of Criminal Procedure. Accordingly, the state's motion to strike defendant's notice was denied. Okay. To date, the state filed a motion in limine to exclude battered spouse syndrome evidence or any mention thereof until the defendant testified to something that is a justifiable use of deadly force. And we saw how terribly this was argued just moments ago in court. Let's see if the written motion makes any more sense or provides any more understanding than the terrible argument that was presented in court. However, okay, so to date, the state motion in limine to exclude battered spouse syndrome evidence or any motion thereof until defendant testified to something that is justifiable use of deadly force. However, the state's contention is without merit, has no legal basis. In fact, there is no more than this is no more than a final attempt by the state to strike defendant's intent to rely on battered spouse syndrome and or prevent the mention of such in voir dire, as we say in Utah, voir dire or voir dire if you happen to be one of those people, and opening. Legal argument. Okay, they presented zero legal argument during the actual argument of this motion a short time ago. Prima facie case for self-defense. Okay, prima facie, Latin for on the face of things, for just like on the face of it, their case for self-defense. Battered spouse syndrome is not a defense in itself. Rather, it is used in conjunction with self-defense. JC, don't get me started. Anybody, and see, this is where the seemingly confused lawyer and we agree. It's voir dire. It's voir dire. That's just how you pronounce it. It's voir dire. Don't argue with me. Battered spouse syndrome is not a defense in itself. Rather, it is used in conjunction with self-defense. When self-defense is asserted in a criminal case, only some evidence need be shown that the killing was justified. You have to show on the face of, just on the face of it, not digging deep into the evidence, just on the face of it, it looks like the killing was justified. And how on earth he thinks this killing looks even remotely justified, I don't know. The state of Florida must then prove beyond a reasonable doubt that the defendant did not act in self-defense. So again, if the court allows a self-defense argument, then the burden of proof shifts. Normally it's the prosecution that has the burden of proving that something happened. Here, once you get this self-defense thing going, then the state has the burden of proving that something didn't happen, that they have the burden of proving it wasn't self-defense. The state can meet its burden through rebuttal by or inference, in this case in chief. See Tillman v. State. Furthermore, a scintilla of self-defense evidence presented by the defendant warrants the instruction. So even if you have a scintilla of evidence, you have to allow the instruction regarding self-defense, in which the court must provide if there is any evidence to support the theory, regardless of how weak or improbable that evidence may be. So the defense is saying that regardless of how weak or improbable the evidence might be to support self-defense, if there's even a scintilla, if there's a wisp, if there's a slight note of self-defense wafting through an open window from the neighbor's house, you still must give the jury instruction regarding the self-defense. It then becomes the jury's role to weigh the evidence, not the state. To that end, the state's request is premature procedurally. The purpose of voir dire, or voir dire, to exclude the mention of battered spouse syndrome before the defendant testifies would be a miscarriage of justice and ultimately infringe upon her right to a fair trial. The purpose of voir dire in Florida criminal proceedings is to obtain a fair and impartial jury. Defense counsel may inquire of veneer their willingness to and ability to accept an affirmative defense. Finding the trial court abused this court case here found that the trial court abused its discretion in unreasonably limiting defense counsel's ability to question prospective jurors on the sole defense presented at trial. All right. And the judge must allow counsel the opportunity to ascertain latent or concealed prejudgments by prospective jurors. Okay, so there's this case that they're quoting, the Simpson v. State. They're quoting states, it holds that you have to be able to question potential jurors about concealed prejudice or prejudgment. Whether a trial judge should have allowed interrogation of jurors on specific subjects is reviewed under an abuse of discretion standard. Specifically in Simpson, the court reversed and remanded the matter for a new trial, opining that battered spouse syndrome was at the heart of Simpson's defense, and because the trial court did not permit her attorney to inquire into possible juror bias on that issue, the trial court abused its discretion. Therefore, the defendant shall be permitted to mention and inquire as to juror bias regarding battered spouse syndrome, justifiable use of force, and self-defense at all relevant times. And finally, Wagner. The state's reliance on Wagner is premature. Wagner does not preclude a defendant from asserting self-defense in getting the battered spouse instruction because of statements made by the defendant before trial. Holding this State v. Wagner held that a defendant is unable to proceed with both battered spouse and accidental killing. That's one thing that was talked about. Okay, well, let's read this last sentence. However, in the instant matter, defendant has not testified at trial yet. Thus, the state's reliance on Wagner is misplaced. So this idea here is you can't wield the same information as both a sword and a shield. You can't rely on self-defense and say this killing was justified because of X, Y, and Z, and at the same time say it was an accident. I didn't mean to do it. Self-defense implies that you intended to do it, but you were justified in doing so. So therefore, you can't say I intended to do it, but it was also an accident. But he's saying we don't have to get there. We don't even have to get there because the defendant hasn't testified. But we saw the judge's ruling on this motion, and what the judge decided on this motion was that the part where the defense requested that the entire battered spouse syndrome defense be thrown out was overruled. It was dismissed. No, you can't do it. We're not going to throw the entire thing out. We're not going to throw the entire argument out. But the second part of the motion was accepted, to where the judge said, you can talk about it in opening statements. You can mention the battered spouse syndrome in the opening statements, but you're not allowed to have anyone testify, any experts testify about battered spouse syndrome and whether or not she suffered from it, unless or until you present some evidence that there was an overt act, a specific act that led Sarah Boon to believe that she was under a threat of imminent bodily harm or death. You have to do that first. Then if you establish that there was some overt act, then you may be allowed to call your expert witness to testify she was suffering from this battered spouse syndrome. So that's the argument on that. And I guess we are quite a bit behind here. I forgot we're behind on chat. So the court is back about 5 minutes ago. All right. I forgot we're running behind. So let's remove this and bring up the court. I forgot we talked a lot. All righty. Let's fast forward to the court talking and bring this up. Let's see. Oh, they're still talking here. Huh. Right. I cannot hear the court.
All right, court's
There
going
we
to step out for 1 second, and then you can email that exhibit list to Madam Clerk, and then we can go from there. Thank you.
Okay. All right. So they got back just to say they're going to take another break. What was that? All right. We are now officially caught up. See, this is how we're going to be doing this trial. And this is why we do it this way. Because a lot of us, we just can't sit there from morning until night and listen to this for 8 hours. So how I run the run trial streams on my channel, this is a good kind of point in time to talk about this. Let's put this down here so I can be more personal with you. This is how we do the trial streams on my channel. We'll do the first day morning live, and we'll go to the lunch break, and then we'll shut it down. And then the next day we'll do the afternoon of the previous day at 1.5 speed, 1.25 speed, depending how fast we can get away with. So that we will be watching it faster than normal. Plus we get to skip all the breaks, all the sidebars, all the fuddling around with equipment, all the audio problems. We get to skip through that. And then once we finish with the previous afternoon, we will start with the morning session of the current day. And we will watch that at an increased speed until we catch up. And then we'll watch it live at normal speed until the lunch break. And then we'll do it again the next day. So we'll always be just about half a day behind, but you'll be able to watch it faster. You won't have to be futzing around with these 15-minute breaks that end up being 30-minute breaks, or like this, the court saying, okay, let's take a 15-minute break. He takes 20 minutes, come back and says, okay, let's take another break. It provides a little more streamlined time. So that's how we do it here. And it also allows you the opportunity, if you want to watch it live through the whole day, to do that and then come back and watch it again with me as we break it down the next day. It's proven to be pretty successful. And I know like a lot of people in Europe and Asia enjoy this because we're all asleep over here on this side of the world while all this is going on. For example, right now it is 1 a.m. my time. Yeah, it's a oh, Silent PS likes this. So I do too. That's why we've decided to do it. I'm not sure what we should do here because the next document we have to read is a 10-page snore fest about discovery. So I think we'll just kind of hang on to that and bring it up at some point if we need to. Sibling Creature, who is clearly on the east coast of Australia, says it's almost 3 a.m. here. Telesentencing today too. Oh, wow. I remember when that was supposed to be in the future. Time has moved quickly. The night is young. It's almost 6 p.m. here. Like I said, I don't know how long they're going to take before they go to a lunch break. But at the lunch break, which is, I said, we'll shut it down at the lunch break today, and we'll resume tomorrow or the next day, depending on how it all works out. But at the lunch break, we will be joined by a special guest who you may know from the Take Care of Maya trial, the Maya Kowalski trial. She's also here in chat, a lovely, wonderful person, Jules. Jules is in court, and she's been watching this from inside the courtroom. Once we get to the lunch break, Jules will come and join here for a brief period of time. We'll let her tell us what's going on inside the courtroom. Oh, read her letter to the divorce court. I have her letter to the divorce court in it's like JPEGs. Like each page is a separate image. I'll have to string them all together, and we might be able to do that tomorrow or the next day on a long break. Big Al, you love kimchi's good stuff. Do you like kimchi and eat hot or cold? Fried kimchi, boiled kimchi, cold kimchi, it's all kimchi and it's all eaten. You can't be in Korea and not eat kimchi. It's a staple. It's with every rice, and kimchi comes with every meal. Hell, if you go to a pizza shop, they'll at least give you pickles, and if you ask for kimchi, they probably have kimchi there too. It's just part of it. Woo, Jewel, says Joe Choi. All right, chat. We currently have 11. We have 1,100 people here. Basically, we're gonna keep doing this until the court comes back. I have to keep checking to make sure I didn't pause it or something. It's up to you. Chat, this is now in your hands. Smopo Vienna, what's up, brother? Hit the like, folks. Jeff is the best law tuber. Vice Squad rocks. Smopo Vienna, he is the manufacturer of one of my favorite coffee mugs, one of my favorite shot glasses, and he also handcrafted a ceramic alien face hugger pipe for me, which I really, really enjoy smoking. The thing is beastly heavy. But make them lighter next time. It's beastly heavy, but it's a great pipe. Smopo Vienna, thank you so much for being a supporter for 15 months. Do you like everybody likes bulgogi, don't they? Just it's spicy marinated beef cooked over flames. Kimchi pizza is a thing. That does exist here. Pizza is, of course, Korean. Oh, yeah, that's old school there, David Nelson. Almost noon here on the East Coast in Virginia. Oh, I wish it was lunchtime for the court. I'm 1 hour behind. What am I watching? This is effing nuts. Oh, this is knucking fuds. Well, how did you get an hour behind, Calamity? Anyway, an hour from now, you'll see me reading this comment. So, cheers. I just want to watch you smash some Boone Tang. Well, we've completed the Boone Tang for the day, and we have moved on to an amazing peated Scotch from Islay, the Kilchoman. Kilchoman Scotch is some great stuff. This is their Machir Bay, distilled and matured and bottled by Kilchoman Distilleries, an amazing, fairly young distillery on Islay in Scotland. But this is great. It's a fantastic Scotch, non-chill filtered, natural colored. One of my favorites. The Machir Bay is one of my favorite. Good. Oh, do I owe you guys a terrible shot? Oh my Lord, I do. No, I don't yet. Do I? No. 10, 20. Oh, okay. We're about $10 away from the punishment shot. All right. I don't know it yet. Yeah, we're about 10 away from the punishment shot. So, Corn Pope. All right, we're just waiting for the court to come back. People here, the 1,072 of you that are still sticking around. We're just chilling, hanging out, and waiting for the court to come back. Oh, let's talk, Rob. Let's talk trivia, Rob. Jeff, are you planning another getaway trip? And if you do, could you please send some more vid about it? I would really enjoy just keep scrolling, international camping that goes on. I've been watching several channels. I was actually planning on going camping this weekend, but it looks like it's going to rain. And literally the last 6 times I have been camping, it has poured rain. It poured so much rain. 2 times ago, I threw my tent away. I'm just like, just F it. It's muddy. It's soaking wet. The ground is soaking wet. I threw the tent away. And the last time it rained, and I made the video, I left the tent there for a day, and I came back, and I threw away the bed. So I canceled my camping for this weekend. All right, we're back.
State of Florida versus Sarah Boon.
But Robin Lane says, super sticker. Thank you so much for the $10 sticker. Super sticker. We'll do the punishment shot in a minute. Thank you so much. And let's embiggen.
Thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's 5th amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
I did want to say that the notice of provision of defendant's 5th amended exhibit list was e-filed on October.
Dude, use the mic. We didn't hear a damn thing you just
Correct.
said.
But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
I'll be right back.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
I don't think he sounds like he doesn't know what he's doing. Like, both of his arguments he's made today have been, in my opinion, like really, really bad. It's like he doesn't want to reveal anything. He doesn't want to talk about anything, but it's coming off like he doesn't know the answer to the questions.
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to
Madam
the
Clerk needs some
very
D.
narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos.
Hey, the dogs are back.
There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
Receive the D without objection.
So just to give the court an example.
Yes.
On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos. 2/23/2020 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boon, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th.
Prosecutor, why are you suddenly talking like William Shatner?
Conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between
Spock,
him and the
he
family
must get
with the
the
defendant.
defendant a phone.
And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of that child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that
I'm ruined for PDF
Um,
files these days.
and
I
we are
just think of
submitting it for
one
the court's
thing.
Review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the Second District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the Fourth District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E versus State.
Why aren't you doing this in front of a microphone?
District Court of Appeal cases as well from 2017. The basics of these three cases are just a very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the
Yeah, the
offense.
getting rid of him thing. Ugh.
Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay, and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. Can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
All right, we're going to just make a little brief pause there. Wow, it seems like they're both sides are just tired now. I think they need a lunch break. Brian Miller says, let's see if we can get Jeff to 100,000 before Melly retrial. It's a year from now. That'd be super awesome. We're a little less than 19,000 away. Super cool. Smopo Vienna, hit the like, folks. Jeff is the best law tuber. Vice Squad rocks. Again, thank you very much. Smopo Vienna, you rock too, brother. Thank you so much. And I love your pipes and stuff. Robin Lane with a $10 super sticker, a dancing lemon. Thank you, Robin. I appreciate that very, very much. And Jill M says, drink up, Buttercup. Nathan says $8. You got each other covered, and we'll do that very, very quickly right now. But Duncan Idaho with the $5. It's funny how if you censor a bad word, people find a way to convey the idea anyway, e.g. PDF file. Almost like that's how language works. Hey, YouTube. Yeah, it is a thing, but like I said, I cannot hear PDF file anymore without thinking the other thing that we're not allowed to say, so we have to cover it up by saying PDF file. But anyway, what everybody's talking about here is we have two tiered. Really quickly, the emotional support potato pig dogs, Yoda and Strawberry here, get unlocked at the $100 point. If we get to the 200 level, that unlocks the punishment phase, because Chad accuses me always of keeping my dogs behind a paywall, which I don't do. It's just it's an achievement we unlock. It's just an achievement. So we unlock the achievement, and but my punishment for unleashing the emotional support potato pig dogs after being held behind a paywall is when we get to the 200 level, I am required by the rules of Legal Vices internet channel here on YouTube to consume a shot of horrifically bad whiskey. That's how I clear off the bad stuff from my whiskey cabinet. We're almost done. Thank God. I've had this bottle for like 6 years, 5.5, 6 years. It's Costco's Kirkland brand blended Scotch whiskey. This is paint thinner. It is really, really bad. And I believe this will be the last shot. We have killed this bottle. Thank you, Chad, for helping me kill this bottle after 6 years. This is really, 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 really bad whiskey. But thank you so much, Chad, for the support. I will gladly accept the punishment for all of the rewards you have heaped upon me. And by the way, we're about 50 away from, I guess we're 55 away from tier 3. But thank you so much, Chad. I appreciate the support. Let's get on with it. Not good. All right, give us your rebuttal to that argument, sir. Oh God, that's bad.
Judge, I think this procedure calls for a lot of speculation as to what these photos examples of the photographs. What's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce.
Correct.
It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case.
Well, please speculate.
How can
for
I
us.
do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, or they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence.
Chad, you're
Defense.
killing me.
Either objection or no objection at that
Killing
time.
me, Chad.
I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection.
What the fuck is he
I don't know what they're
talking
using it for.
about?
Guess what, Judge? The videos of the suitcase, we didn't object to those.
I don't know.
Do you know why?
No, what he's
It was
talking
clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to
That's just
introduce.
speculation,
Nobody
Judge.
Covers the suitcase video to me. All
No, it
means
doesn't.
all.
the suitcase video is listed in in the things that we don't object to.
I don't know that. I have image underscore 0954. I don't know what that is. Image underscore 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court?
Lay the fucking foundation.
In a minute.
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is,
All right, Chad,
wanna
I'm
make
this close to
sure,
losing
because
my
I
shit
didn't
right
object
now.
to something on here. It waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct.
What?
So, I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently. Okay. 30 years I've never had to do this in a criminal case. Okay.
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then y'all parachuted in on August the 30th.
Yes.
There was no order, there was no
Parachuted in.
request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden.
Chain of custody.
Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever I used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity blobbity with this software.
Blobbity blobbity. That's, we're done.
Out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about.
I don't think we can have an intelligent discussion at this point. Blobbity blobbity.
The photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge. This is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay.
With all due respect, sir, what the fuck are you talking about? I mean, even the judge, like all the judge had to say was, okay. Chat, I don't know what's happening here. This is not good. I don't have any idea what's happening. Even the judge does. Literally, we're gonna go back. Just listen to the judge. The judge listened to this for however long he went on. He's like, okay. Oh, blobbity. This is terrible.
Bar me at that time.
Okay. I'm going to overrule your objections.
You think you're going to overrule his objections? Yeah. Oh, there is a surprise. The judge overruled those objections. Oh my God. Mr. Owens, I respect you. You are a hero. Thank you from the bottom of my heart for having the courage and the tenacity and the guts to step up and stand up for Sarah Boon, to represent her and to ensure she gets a fair trial, to make sure that her constitutional rights are protected. But dear God, don't let this guy examine or argue anything during the trial. For the love of God, if you want to have any chance, don't let this guy do anything during the trial. Holy shit snacks.
The reasons that I previously identified, you can raise your objections at trial if you deem necessary. But based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so.
And this is not his first time. He's been doing this for 30 years. Oh, God.
Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state doing its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
Oh, blah-ba-dee-da, life goes on. Oh, life goes on. Oh, that's terrible. Thank you, C. Winterstorm. So he's saying there are pictures of her son Lucas that the state is trying to bring into evidence, and the state's like, I don't think so. Let me check my computer here. Blobbity blobbity. It sounds like it's a bad Adam Sandler Saturday Night Live skit. We're like, blobbity blobbity. It's like Adam Sandler doing a Bill Cosby impression on Saturday Night Live. We got pictures of the child, blobbity blobbity, and oh my God, this is crazy. All right, well, he's going through that. Duncan, Idaho says, Your Honor, I object. What are y'all objectifying to? Oh, no. And Bush McFadden, see, Your Honor, the who of the what, which the why is we got a way to say is caught before the horse. You didn't grease the wheel. You can object. Blobbity.
Folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
I don't see any. So basically, no, they're not trying to introduce any pictures of the child. What is going on here? Tina Lewis with the $10 super chat. Is this attorney trying to get this case postponed by playing ignorant? I have no idea what's going on. I don't. Bush McFadden with the $5. I just want to ask you something, Your Honor. Can I be excused? Fart belch. The which of the where and the why may have made me ill. Oh, this is so bad. Oh, my Lord. And Emotional Lemonade says, is he drunk? No, okay. All joking aside, honest to God, I was gonna right before you sent this, I was gonna say, unironically, unjokingly, I'm concerned. He has some speech patterns, some behavior patterns. I'm actually, and I know I'm horribly wrong, but it's just coming off as someone who, if you asked him to submit to a BAC check, a blood alcohol content check, I would not be surprised. I know he's not, because that would be ridiculous and that would be horrible for a lawyer to show up in court to drunk, but it's not unheard of. But I would understand if someone asked him to submit right now, because that was wild, like unironically. And I'm not saying he is, because he's not, because that would be bad. But I would understand it if someone thought he was. Can you get sanctioned for being drunk in court? Oh, hell yeah. Bad things happen if you show up to court drunk. You get sent to lawyers helping lawyers and other things like that. Wow. We already read that. Oblabadi, da. Life goes on. Update: Robert Tellez, the Clark County, Nevada, the guy who blamed the murder of she was a real estate agent. Oh no, she was the council person, whoever it was he murdered. He blamed it on ninja assassins, unknown ninja assassins or something. He was just sentenced to life with possibility of parole after a minimum of 28 years. Draskovich filed a motion to withdraw. Tellez is appointed a public defender for his appeals. Cool. Ike Varnas.
I see two images. I could
if I was Sarah's attorney, I'd need to be drunk to defend her. Okay, so there are two images.
recognize it as a reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to moving those two.
Oh my God. So the best they can find is there's a reflection of some children in a snow globe. Oh God.
I just didn't recognize it as children. I recognize it as a crab.
A crab?
I haven't seen the picture, so I'm at a loss.
I didn't think it was children. I thought it was a crab.
I'm going to remove those two.
Oh
Take care of that issue for you, sir.
That takes care of that issue, Jeff.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now. They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witness is in all, and the court has told me that I don't waive my objection, so I understand the court's rule.
All right, thank you very much. Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed.
Okay.
We'll just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the team hand.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return and we can address all these objections tomorrow. And we'll adjust those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Okay. They're done with the motions. Chat. People in chat, do not leave. Stick around. Right now, we have 1,041 people here. Do not leave. We have a very important thing happening here. So please do not leave. All right, here's the deal. They're done for the day as far as these motions go. They're going to pick it up tomorrow, so we'll follow it tomorrow. No big deal. The objections and other things that they're talking about. But right now they have taken a break for lunch, and I'm sending a message because, wow, I'm going to remove the doggos here for this. Say goodnight, Straubs. Good night. Say goodnight, Yoda. Good night. All right, there we go. There's the doggos. We'll bump them out here real quick. It's just you and me, Jan. All right. Do not go anywhere because we have a super special guest that is inside the courtroom watching this happen just feet away, just meters away from Sarah Boon herself. That would be the one and only Jules. She is trying to get out of the courtroom right now to connect with us, to give us a little insight as to what is happening inside the courtroom. What's the vibe in the courtroom? What's going on that we can't see? So as soon as she can get somewhere where she can get connected, Jules will be joining us. Moving forward with this, we've heard the judge say they'll handle more objections and things tomorrow morning, and then presumably they will complete the jury impanelment tomorrow, which means we could begin with opening statements as early as Thursday morning, if not Thursday afternoon. Jules is not on camera. Jules apparently is sitting in the jury box where the jury sit. So yeah, as soon as she pops in here, we'll talk to her for 15 minutes or so. But I really want to get a feel for what the vibe is when dude was talking this nonsense for so long. That was stunningly weird. Oh no, Becca, no. Oh, the vibe is the student who didn't read the book and has to do a book report. No, you are so close to what I was feeling during this. Like listening to that guy answer the judge's questions and to argue his motions. I was literally having flashbacks to law school where for some reason the professor focused on my dumbass and I hadn't read the cases we were supposed to go over that day. And I'm trying to bullshit my way through those cases, through my answers, without cluing the professor into the fact I hadn't done the work, knowing I failed in that task. I was literally having that kind of PTSD flashback sort of thing. Oh my gosh, that was weird. He was very Linda Lou. That's a great way of putting that. He was very off. Yeah. I'm not saying he's intoxicated. I would never imply that. But it was a weak argument. And he's been up there 3 times. And all 3 times he said, I don't want to tell you what we're going to argue. The judge is asking you a question. Answer the judge. Oh, man alive. Now he didn't stop to listen to the judge at all. Was it 2 days ago when we did it? He didn't stop to do that either. And I was thinking it was a Zoom thing. His Zoom connection was crap. His audio was crap. I thought perhaps he just didn't hear the judge, but he was doing the exact same thing, just steamrolling on, just spewing whatever it is he's got to spew. Oh, yes. And he just parachuted into the case the other day on Zoom. Exactly. All right. Let me send a text here to Jules and see how long she'll be. All right. I did fly over to that lawyer's house and stayed the night. So, well, there you go. Kept him busy, did you? Oh, chat. Let's while I wait to hear from Jules, let me just make a couple of little statements here. We've currently got 953 people waiting and watching. And again, don't leave, because hopefully we'll be able to talk to Jules and she can tell us what was going on inside the courtroom that we might not be aware of. Tell us a little bit about the feel of what's happening. 946 of you here. We hit 1,000 likes, chat. That's what I'm talking about. We hit 1,000 likes. We're at 1,054 likes currently. Keep hitting that like button. Let's get us up to 1,100. Why not? Let's get us up to 1,100 likes. And how are we doing on subscribes? How many subscribers have we picked up? Holy crap, we've picked up about 122 subscribers since we started. So please, the 951 of you that are still here, continue to hit that like button. Continue to hit it. Continue to hit the subscribe button if you haven't done so. And if you have, double check to make sure you're still subscribed. Let's keep those subscriber numbers going up. Okay. She's trying to get on with the link is giving her a hard time, which it's known to do. I'm going to copy and give her the link again, just in case. Here it is again, just in case. Right. So she's trying to connect. It's not uncommon. StreamYard, which I use on a cell phone, is complete garbage for the most part. So good luck. Oh my gosh. So, all right, going back to what we've got going on here. Could Sarah now have the strength now to possess lawyers? That would explain the lawyers issue. She's possessing her lawyers. Oh no. Oh man, what a strange day. We have an uncivil law raid here where it says we have a Kurt raid. I guess that was the bling I heard. Don't know what's happening, but hey, we do it. Apparently we do have an uncivil law raid. Thank you so very much. All right, welcome people. And while you're here, hit that like button, hit the subscribe button, say howdy to everybody in chat. I need to double check here while we're waiting. We'll give Jules a few more minutes to see if she can connect. While we're doing that, I have to do some lawyer math here to see if we've actually reached the third achievement. Yesterday, I said we reached the third achievement, but I did like terrible math, and we were nowhere near that. But let's see, we got 50. It's 140, 240. My math is so bad. Looks like we're about 30 away from the third tier unlocked. I can do actual real math because my phone has a calculator on it. Divided by, okay, 130. Okay. Oh, chat, you're so fun. You're so generous. I have to use calculators to do crap. Oh, we're 25 away, I guess. Are we 25 away from it? Yeah, we'll say 25 away from third tier. Anyway, it doesn't matter. Everybody joining from Uncivil Law, please hit that like and subscribe button on your way in. What we're doing here is we're waiting for our in-court person, Jules, to be able to connect here onto StreamYard, and maybe we can get a little bit of insight into what's going on. As you just heard, by and large, the defense got their ass handed to them in the motion department. They won some relatively insignificant motions. They lost big on the battered spouse syndrome motion, where the judge, because the prosecution had either asked that the defense of battered spouse syndrome be completely thrown out, or alternatively, that they not be allowed to raise that issue until someone on the defense's side has proven, or at least provided evidence, that there was an overt act that caused Sarah to be in imminent fear for her safety, imminent fear of grievous bodily harm or death, that would trigger her legal ability to argue the self-defense by battered spouse syndrome thing. He said, okay, we're not going to throw that entirely out, but you can talk about it in your opening statement. But you're not allowed to bring it up during the trial until you have somehow submitted evidence or argument of an overt act that would have caused Sarah to be in imminent fear of grievous bodily harm or death, which would allow you then to maybe call your expert witness who could testify that she suffered from battered spouse syndrome and bring up all the horrible things that George is alleged to have done in the past. So that was a big crushing defeat for the defense. That was an important argument that they lost. Jules is still having trouble. Let me send her a message here. All right, she's saying she's just having trouble connecting, which a lot of times happens. Like the interface between mobile phones and StreamYard is crap. Plus, you get in a crowded courtroom where everybody's sucking off whatever free Wi-Fi is available. Phone lines get congested. It's a bad thing. I've just asked her if we should just call it a day and do a test run tomorrow, or does she want to continue to try? Or do you want to continue? Try to connect. Up to you. All right. We'll just wait to hear what her answer is. Yeah, we're all having trouble after that. Oh, wow. That's a good one. Is you is or is you ain't my baby. What a great song. What time is it for me? It is now 1:52 a.m. in dark and chilled South Korea. Overt act is not relevant. Boone was the aggressor. Well, see, that's the thing. That's what she has to show before she's allowed to present her expert evidence. It's to say, what happened to her? What was the overt act? What was the thing that happened to her? That she has to give some sort of specific statement. They have to present something that happened where she can say, at this moment, right before all of this happened, I felt that I was in imminent fear for my life or safety. And that's why I did this. If she can say that, then that would trigger her to probably be able to call an expert witness to testify to that, and it would trigger a jury instruction regarding self-defense. But she's got to come up with it. There has never been a single overt act that's been brought up yet. So I'm questioning the ability to come up with one. The gentleman who spoke last year, I need to learn his name. Not Owens, the other guy who did doing the speaking. He tried to say the overt act was him trying to free himself. The overt act was him sticking 2 fingers out of a hole, which, of course, nowhere shows up on none of the videos. Somehow that was the overt act because he was trying to get out. And if he got out, he would have fucked her up. That's kind of what he was saying. So the overt act is him trying not to die. That's a terrible, terrible argument. Especially he was like saying, oh, you know, there's markings and bruisings on his hand that show that the only thing they show is what Sarah admitted, that she took a baseball, perhaps he stuck his fingers out and she took a baseball bat and beat him on the hand with a baseball bat while he was trying to get out. That's the best case scenario she can argue. That was so absurd. I mean, I'm stunned. Far be it for me to tell Owens how to do his job. And I do respect Owens, but I would never let that other guy talk ever again in this case. I'd be like, hey, peace out, bro. Thank you so much for joining us for a minute. You are no longer needed. Your services are no longer needed here. That's what I would be telling him. That was just weird. That was really weird. All right, there's a message incoming from Jules right now. Let's see what she says. Jules, our in court, our person in court, our on scene reporter, is sending me a message. She's been trying to join here, but there's been some connectivity issues. So speaking futuristically, how are we going to do this? I'm just waiting for her to drop the dime and tell us what she wants. I don't think there was any hide and seek. I don't either. And one says tag. No one says tag when you're in hide and seek. George passed out or was cracked in the head with the bat. She put him in the suitcase. He was 103 pounds, and she was 140 pounds at the time of the incident. So she outweighed him by about 40 pounds. Don Marie WB, this is my theory right here. That's what I'm saying. That's what I'm saying. That's what I think happened. Exactly what there was because she says they were playing hide and seek. Yeah, she describes a game of tag, but then again, they didn't play tag or hide and seek, and they just thought it would be a funny idea to put him in there. I don't think any of that shit happened. And he had the subgleal bleeding, the membrane. It was like bleeding between the membrane surrounding the skull and the skull. He had the cracked lip. Had another cut near the crack on his lip. I like you believe that he was probably cracked upside the head or passed out drunk and was put in there. That's what I'm thinking. I don't think there was any game of hide and seek. All right. Notorious Jules is unable to connect. It's totally understandable. It happens sometimes. We'll work on it tomorrow. Hopefully she'll be able to join us tomorrow for a bit, maybe a little bit before court starts and during the lunch break again. But so we will defer to Jules tomorrow. We will postpone her. She'll parachute in here tomorrow, hopefully. Yeah, JC, he was 5'2", 103 pounds. She's 5'3" and 140 pounds at the time of the incident. So she was an inch taller and 40 pounds heavier than him. Okay, Madison says that's exactly what I think happened. I agree. So, all right, people, what we're going to do is we're going to shut this down here now. We've currently got 1,007 people watching and 1,100 likes. Thank you so very, very, very much. Yeah, it looks like we were about 25 short of the tier 3 unlocking, which is just a shot of absinthe. So The dogs are here. Yoda has effed off to the sofa to sleep. Strawberry's here. Strawberry saying good night. I'm going to see where we can send 1,000 people. 1,000 people, hang on tight. I'm checking the YouTube studio to see where we can go. We're going to redirect you to somebody. Who is going to be the lucky recipient of all you awesome, awesome people? Let's see. Content. Oh, and we're up to 81,172 subscribers. We only need 28 more subscribers to get to 81,200. That's crazy. We've picked up like 140 subscribers today. You guys are freaking awesome. Content. Let's see. Live. And join me tomorrow because we're going to pick this up tomorrow. Same time, same channel. 9 a.m. Eastern, 2 p.m. UK. I guess it'd be midnight Australian Eastern Daylight Time. And we are going to redirect to who do we got? Popcorn Planet, Recovery Addict. Trial TV Live. Lots of Mystery Science Theater Channel. Lead Attorney. Law Talk with Mike. Let's go to Law Talk with Mike. We haven't rated Law Talk with Mike for ages. So we're going to send it over to Law Talk with Mike. Mods. Thank you so much for everything awesome you do. Chat. Thank you for the ridiculously generous super chats, gifted memberships, purchased memberships, and all that. And for those of you that just sat back and watched, thank you so much for just hanging out with us, for being a part of the Vice Squad. Thank you for subscribing to the channel and liking the videos. That warms the cockles of my cold, dead heart. We'll see you tomorrow at the same time where we're going to continue following this. Thank you so much, everybody. Peace. Let's go on over to Law Talk with Mike and tell him that Legal Vices sent you. Tell him howdy. He's a great guy. If you don't know who he is, you'll love it. See you tomorrow. Peace out.